Hello, in this video we're going to talk about what you need to know about trust litigation. Hi, I'm Richard Barid. I'm an estate planning attorney here with Smith Barid LLC and one half of the Estate Planning Guide. So you've done some basic estate planning, you've put together maybe a will, a power of attorney, and you're thinking about a trust, but people have told you they're complicated. Mostly the complicated work on a trust is done by the attorneys, all the heavy lifting, so to speak, and having trust makes things easier for you. But sometimes there is, the one bad apple spoiling the bunch, and it turns into trust litigation, which is a special kind of litigation. It involves typically a probate court judge or sometimes a superior court judge to oversee the proceedings, and it's a lengthy commitment. It's not something that happens quickly. But let's talk a little bit about what it means. Trust litigation is a form of what we call fiduciary litigation, and one of the most common themes we see is someone who hasn't received what they think they should receive from an estate, especially a trust estate, and so they come in and attack the trust, and maybe the trustee saying that they're not getting their fair share, or when mom put the trust together, she wasn't in her right mind. Or when mom put the trust together, that your brother was at her side, whispering in her ear or even twisting her arm, so that it's a matter of undue influence. So these are the kinds of things that we can wind up dealing with in a trust litigation situation. And to know a little bit about how it works, we ought to think about the parties that might be involved. A trust has what some states call a settlor, we often call a grantor. That's the person who creates and usually the person who funds, that is, puts the assets into the trust. Then there is the trustee, the person who has the control of the assets and a set of rules set up in the trust as to how they can manage and how they must manage and how they must provide for the beneficiaries, which are the third group. You've got grantors, trustees, and beneficiaries. If you get to choose, you always want to be a beneficiary because it is what it sounds like. You benefit from the trust. But it's not unusual, especially when money is involved, large amounts of money, for family members or beneficiaries to get upset thinking that it's not moving quickly enough, or they're not getting what mom told them they were going to get, or someone else is getting an unfair amount, or the trustee isn't doing their job. That's the kind of situation where typically people might hire a lawyer and try to work it out in a mediation, negotiation kind of context, but sometimes, as in other areas of life, sometimes we can't agree. And so there is a process to solve these sort of situations. In Georgia, it's through the superior court. We can dispute a trust, the validity of the trust, or the interpretation of the language of the trust. So this kind of litigation is much like other types of civil litigation, not criminal litigation, but civil litigation. There's a petition or a complaint filed saying, "Judge, here's what we think is wrong with the trust." After that, there's usually a period where everyone has to be served with a copy. All the parties, the beneficiaries, the trustee, sometimes the grantors, need to be served. And once that happens, there'll be some basic negotiation, but if we're not ready to come to an agreement quite yet, there's what's going to be the discovery phase. You may have heard of this before in an auto accident case or something like that, where we might send interrogatories, which are written questions answered under oath. There might be interrogatories and requests for production, which is a request that your client, if you're the one who receives the discovery request, put together certain documents that may be relevant. And in discovery, there's a much broader scope. You don't necessarily have to go for evidence that would be admissible in court, but just something that is a piece of evidence or several pieces of evidence which might lead you to admissible evidence. So it's pretty broad. It can be pretty time consuming to respond to those kind of discovery requests. And there's even a kind called request for admissions, where the other side would be asking your client or asking you to admit that certain things are true. And one tricky thing about that is if you don't answer in the time given by the court to answer those, then the things that they have suggested you admit are considered to be admitted. It can be devastating to the case of the party that fails to respond to that discovery. So once all the discovery is complete, there's often at least some informal negotiation because the lawyers know where they stand. The parties start to have a better understanding of what is going to be acceptable and what's not, and what may happen in a courtroom. And we'll negotiate, and probably 80 to 90% of these cases wind up in what's called a settlement. Not immediately, but at some point during this process before we get to trial. And lawyers who try cases daily sometimes have mock trials for if there's a large monumental reward to be gained by litigation if you win. They have mock courtrooms or just set up a conference room as a mock courtroom and walk it through, meaning appoint someone to act as the judge. That person should know who the judge is and what they're likely to admit and not admit and how they're likely to react to different tactics in court. Someone plays the defendant's attorney, someone plays the plaintiff's, and you work through that as a way to, just like you're doing a play actually. make sure everyone knows what their lines are, so to speak, what you're trying to accomplish, and you can try out different types of arguments and get reactions from people who know what they're talking about. But you can tell by this short list of things that make up the timeline of a trust litigation situation, it is a lengthy commitment. If you decide to take on litigation, to hire an attorney and litigate over a trust, you need to be ready that you almost certainly will not gain anything from the trust faster that way. In fact, it'll be probably much slower. Civil litigation cases, because the courts are so packed, sometimes take a year, 2 years, 3 or more to get to a final hearing stage. So if there's anything you can do within the family or the beneficiaries to not have to litigate, to not have to go to court, it'll benefit everybody, because the trust estate will be handled faster, and we won't be draining trust assets to defend the trustee or the grantor or whoever it is that's being accused of doing or not doing the right thing. I hope that's helpful. We'll see you next time. I hope you enjoyed that video. If you did, please click below to subscribe and hit the little bell so you'll get a notification every time we post some. Right now, we're posting about 3 videos a week with all kinds of useful estate planning information. So click right down here so you don't miss anything about estate planning, and click right here on your screen for the next relevant video.